Hi, welcome back to Chalk and Gavel, everybody. It's great to have you with us. Just a real quick note before we start. Don't forget to go check out our website, chalkandgavel.com. We've got great merch up there, and we would love it if you would support the show either through buying some merch or becoming one of our show supporters in other wonderful ways. We've got a feedback form on the website. You can let us know what you think. And if you have any cases that you think we should hit on, we'd love to hear from you. Like, rate, review, all of that stuff. And we really appreciate everybody tuning back in every couple of weeks and checking out this little show we've got. Thank you so much for all of your support. Thank you for listening. Thank you for watching if you watch on YouTube. And let's just go ahead and get into it. Sound good?
Sounds good. Jamie, what happens after the Supreme Court says that parents have a right to opt their children out of public school instruction that contradicts the religious beliefs they want to instill?
So here we are in a post-Mahmoud world. It's going to be complicated and ambiguous, probably.
Probably.
You know how we've been talking about how all of these cases have started to change the landscape lately, right? The case we're going to talk about today gets right to the heart of how these changes are starting to play out in schools. So if you have any stake or interest in the nuts and bolts of how schools operate and carry out their missions, listen up. You might find this one pretty interesting. Okay? So remember how all the way back in episode 48, which was like, what was that?
A year ago.
25 episodes ago or something? That's nuts.
Yeah.
It was last summer, I guess.
We've been doing this a while.
Yeah, we have. So we covered in episode 48, we covered Mahmoud versus Taylor. That was the Supreme Court's decision that parents have the free exercise right to opt their students out of the curriculum that, or any curriculum that contradicts their religious beliefs. Okay. And you remember how we said that it creates more questions than it answers, that Mahmoud decision. Particularly around how to provide the notice and the opportunity to opt out.
Right. Yeah, because it leaves all of the practical questions completely unanswered.
Right. Exactly. So here we are dealing with how to implement the vague standards of Mahmoud. So schools have started grappling with that vagueness, and courts are starting to weigh in. So today, we're covering Allen L. versus Lexington Public Schools. And this is one of the first court decisions to apply Mahmoud. All right? Not only does this case highlight the practical challenges that Mahmoud raised, but it also shows how the very meaning of Mahmoud and the scope of this new opt-out right are really up for debate.
Right. Yeah, this one has some implications both for the chalk side and the gavel side.
Yes. We're going to cover it all today. Welcome to Chalk and Gavel, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a school attorney and a high school English teacher. Now we're both professors of educational leadership, telling the fascinating stories connecting the courtroom to the classroom.
Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright. So the kids are alright.
Okay, welcome back, everybody. Before we dive into this post-Mahmoud religion opt-out parent right free exercise
You're right. Post-Mahmoud
barrel
has
of
like
laughs,
kind of an apocalyptic sound to it.
well, you know, here we are.
It was a sea change, right?
It was. Yeah. It was. There have been many over the last decade or so. Anyway, before we get into that, we have a bell ringer. Or
we've got two bell ringers. Yeah, today we've got a BOGO bell ringer.
Getting your money's worth, folks.
None.
Yeah. All right, what you got for us, Chris?
So first up, I've got an update for you on a bell ringer we did a while ago. So this is related to the incident involving a 6-year-old student who brought a gun to school and shot his first grade teacher.
Right, we did.
So you probably remember that. Last time we talked about it, we were talking about how a jury awarded the teacher $10 million after it found that the assistant principal was liable for ignoring warning signs that the child had a gun and was a threat. So that was a civil action, so a civil lawsuit, and that's why there was money damages. At that time, we talked about how the student's mom had been convicted or sentenced to a couple years in prison for child neglect. And there were currently, at that point, charges pending against the assistant principal for criminal charges, correct, for felony child neglect. And so the update is that the court dismissed those charges against the assistant principal.
Okay.
Yeah. So
dismiss the criminal charges.
Dismiss the criminal charges. As far as I know, that $10 million verdict is still there.
Right.
So that's the civil side. So this is criminal that would have jail,
right.
That sort of stuff associated with it. So the court basically just said, I'm dismissing the charges because based on legal principles alone, so that's what the court said, what the assistant principal did was not a crime under Virginia law. So it just didn't fit into the bucket of child abuse. Or neglect, rather, as according to this judge. So the legal saga seems to be coming to an end then, based on that situation.
Right.
So the AP was not criminally responsible or guilty of a crime, but the AP was civilly liable, which is why the teacher got that $10 million judgment. And then mom was also found guilty of child neglect based on her role in the student bringing a gun to school.
Yeah.
So lots of interesting moving pieces there in the legal fallout for that tragic situation.
Right. And as we discussed in that episode when we covered that case, this is also uncharted waters as far as liability is concerned, civil and criminal, when it comes to these school shooting and other, big safety kinds of situations.
Right. And we've seen, we've seen a lot of legal movement where holding the parents legally responsible has become more common. And then, trying to sue the school or the school personnel for their role in either, exacerbating or not addressing these things.
Right.
It's definitely an area where people are trying out some new legal theories.
Right. All right. What's the other bell ringer?
So the other bell ringer, I've got a quick Supreme Court news alert. Trying out sound effects.
I don't know when I hear that noise or that phrase, Supreme Court news alert. I don't get very excited anymore.
I keep joking with people that it's a good time to have an education law podcast. It's a bad time to be involved in education law. Just everything is changing all at once.
It really is a lot to keep up with. When I started doing this,
well, there were decades. There were decades where the Supreme Court didn't touch education. Like the early 2000s. There's one or two maybe, but the last 5 years have just been constant, nonstop education law cases, including a new one.
Here we go.
So this isn't a K-12 case, but it could have implications for K-12 teachers and staff members. So the Supreme Court just agreed to hear another case. This one involves whether Title IX, the law that prohibits sex discrimination in education, we've talked about it before, whether that allows employees to sue their institutions directly. So in this case... Yeah, I know. So this is about kind of the scope of Title IX. Wow. So in this case, 2 staff members sued their universities for alleged sex discrimination. However, the 11th Circuit said that Title IX does not provide employees with a private right of action because the text of the law was designed to protect students and other participants. So most courts have come out the other way.
The other way, right? Yeah, the
and
other
not
circuit
narrowed Title IX.
So now we have what we like to call a circuit split.
Now we have a circuit split, yes.
So that
which is one of the reasons that the Supreme Court will take up cases is to address circuit splits.
Right, because basically what it means, just for those of you who might not be aware, and I don't know how many times, if any, we've even talked about this on the show. We probably have, because we've done this 75 times. But
the Supreme Court's taken up a lot of cases, and not taken up cases too, right?
Right, but a circuit split is basically when you've got similar issues that have been adjudicated in different areas of the country, and the decisions at the federal court levels just below the Supreme Court. So as high as you can go before you get to the Supreme Court, those courts look at those same issues and come out differently, right?
Right.
And what that creates is you've got similar situations throughout the country where the law is applied very differently or and so.
Which is not very helpful.
No, it's not. It's like,
right.
You can go live in this region and not have to worry about this thing that you would have to worry about in this other region, right? Like this thing is legal over here and it's not legal over there.
Right.
And that gets really tricky. And that's usually when the Supreme Court will come in and say, okay, we need to settle this.
Right, right. And that's one of the reasons why, say, context is so important in education law, because not only does what happens matter really deeply and could change the outcome, but also the law is different depending on where you are.
Exactly.
Or it could be. And, every state handles education differently. Federal issues should be consistent, but they're not always consistent depending on your jurisdiction.
Right.
So that question about whether or not Title IX includes employees, right? And there is a question about whether or not Title IX kind of overlaps or provides additional protections beyond those of Title VII. So we've talked about Title VII. Title VII is an employment statute that prohibits employment discrimination based on, among other things, sex. So like if we take away Title IX, it's not like employees have nothing. It's just like, is this another or an additional or even a more expansive
lever? You like to use the word lever. Yeah.
Yeah,
lever.
I like that. Yeah. Especially the hand gesture that goes with it. So that case will be heard in the 2026-27 term.
Fantastic.
Yeah. Right. So we're not out of a job yet.
No, we are not. We are not. It's the gift that keeps on giving, Clark.
It's not Ghostbusters, but
it's not Ghostbusters. It's not Spaceballs, but it's a National Lampoon's vacation movie. So that's in our wheelhouse.
I think so.
All right, you ready to get into today's post Mahmoud apocalypse case?
Yes, I am.
Yeah. Okay, let's do it. All right. So we said at the top of the episode, we're covering Allen L. versus Lexington Public Schools, which is one of the first court opinions to try to apply Mahmoud. Okay, and this is the request for an opt-out thing. Hopefully this case starts to answer some of those lingering questions that Mahmoud so graciously didn't answer.
Right. I'm not optimistic.
No. Well, because you've read the whole thing.
Well, also, yes.
Okay, so this takes place Lexington, Massachusetts, which is a suburb of Boston, and we've got a student, JL. JL was a 5-year-old kindergartner at Estabrook Elementary School. And now before the 25-26 school year, when JL was to start kindergarten, JL's father, Alan, became aware that Lexington Public Schools had introduced curriculum materials addressing topics related to sexual orientation, gender identity, and family structures to the curriculum that he viewed as conflicting with his religious beliefs.
Okay. I love the passive language that courts use. He became aware.
He became aware.
Not how he became aware.
Well, that doesn't matter.
Yeah.
Right.
I know. It's just an interesting part of the... Well, wait a second.
Sorry. I'm getting ahead of myself. All right. So let's talk about what Alan's religious beliefs were. Okay.
Seems important.
These things conflicted with his religious beliefs. So what were they? Allen describes himself as, quote, a committed practicing Christian with sincere and deeply held religious beliefs that guide his daily decisions, his parenting, and his family's life together. His beliefs also include that, quote, God created people in his image, either male or female, and that sexuality is designed by God to be expressed only within the context of a one-man, one-woman marriage, unquote.
Okay.
Okay. Because of this, he believes that it, quote, violates his religious beliefs to allow JL to be instructed in content that focuses on diversity, equity, and inclusion. Okay.
I don't know if I see the connection.
I was just going to say that felt like it came out of nowhere.
Right.
Anyway, I will continue his quote. Violates his religious beliefs to allow JL to be instructed in content that focuses on diversity, equity, and inclusion issues, including issues of race, gender, and sexuality, taught from a secular worldview.
Wow. Okay. So we started small and we got really big.
Yeah. I'm a committed practicing Christian with sincere and deeply held religious beliefs, and that moved to God created people in his image.
Sure.
And it's all to be expressed only within the context of a one man, one woman marriage. And then it goes to anything that has to do with diversity, equity, inclusion, anything that has to do with race.
Secular worldview.
If we're teaching about any of that stuff from a secular worldview, from a non-religious worldview, that violates my, like that to
that could
me
be. If that's how
it's like, if you teach about anything related to race, gender, sexuality, diversity, equity, if you teach about any of that stuff from a non-religious standpoint, that goes against my religious beliefs. Is like, that's how I read his statement.
Yeah. So that's one of the things about Mahmoud is like, how do you like cabin this right? Like, how do you put guardrails on this right? Because it sounds like, you know, you could make the same argument then, if that's sufficient, like you could make the same argument that like anything being taught from a secular worldview violates my, like all of science could violate a secular worldview, or could be presented in a way that, you know, excludes religion. Right. And so like,
I'm not, you know, I'm not trying to say, you know, I know where I stand on this issue, and I'm not, I'm not trying to make a big stance here. I'm trying to point out that this language, like you said, leads me to believe like, okay, where could this go?
Right. Where are the lines?
Yeah, exactly.
Yeah. Right. And yeah, because none of this is questioning the religious beliefs of families, right? Like, it's just like, okay, well, how far does the implications of this line of inquiry go?
Exactly.
Yeah. One thing that I do find really interesting here, though, is we start with, you know, very traditional ideas about like traditional marriage, about traditional ideas about gender, you know, there's only men and women. Then we get some political language in there around DEI.
Yeah.
And I think that's just a really interesting like indication perhaps about like how like these religious beliefs and also this political climate are kind of like merging in interesting ways, getting intersected.
And I don't recall from Mahmoud, I don't recall hearing a lot of DEI language.
No,
I don't think that appeared really anywhere.
No.
In Mahmoud.
Not that I remember.
So, okay. So let's keep going and dive into the facts, because this stuff is interesting. And I think that this has, you know, like we've said, this has potentially got some very real implications for schools.
Right. And this story could be happening at any school, just given how it plays out.
And it probably is happening at a lot of schools.
Right.
Okay. So at the beginning of the school year, Allen met with JL's teacher and a student support instructor to express his concerns about the content in the kindergarten curriculum. Now, I think there's a student support instructor there because JL had an IEP, and that might have been a special education teacher, but we don't have very many details about that.
There's a slight irony there that JL is a student with a disability with an IEP, because the Individual Disabilities Education Act is all about inclusion of students with disabilities. But that's probably neither here nor there.
I will say that is a very interesting point, sir.
Why, thank you.
Now, we don't have any details of what actually happened in that meeting. But what we do know is that after that meeting, and things start moving real fast here, folks.
Right.
After that meeting, Alan sends an email to the school and requested that JL's full class schedule and the syllabi for his classes be sent to Dad. He requested those things. He also requested that JL not attend health class the following Tuesday.
Right.
Okay.
So like things are starting off, like this is how I would expect something like this to start. You start by meeting with the teacher. And then like, okay, well, hey, I've got these concerns. I want to know more. Can you give me more information?
I meet with the teacher. My concerns aren't addressed. And so I'm going to turn around and say, all right, I need more information. And until I get it, let's put a hold on him going to this class or whatever. Right.
Right. Yeah.
Interestingly, the district responds to his email with a link to a high-level overview of the kindergarten curriculum. Okay. And according to Alan, this didn't include any actual syllabi or curriculum. Okay.
Sure. Which is pretty typical because like, in our college classes, we have a syllabi that lists all of our readings. But like, to me, a lot of this comes down to like transparency questions about like how transparent is the curriculum for families.
Well, and that was the question that I had when I was reading through this case is there were a lot of questions that I was left wondering about, both from the school's perspective and the parents' perspective, right?
Yeah.
Like what did or didn't exactly the school provide? What did or didn't actually the parent do or ask for? Or, like there were a lot of those questions that I had going through my head as I was reading through this case.
Right.
And I think, as we will talk about, those are very, very critical questions. To some, not to some courts.
Right.
But
yeah.
But those are some critical questions, I think.
I agree.
So he also, Alan, after he got what the district sent him, okay, Dad reviewed it and he sent another email to the kindergarten teacher seeking to opt JL out from any DEI curriculum. So this is where the DEI stuff now comes in. Okay. And in addition to excusing him from health class. Okay. So like you said, like we're starting to get that conflation of, stuff that goes against my religious beliefs, including DEI.
Right.
Okay.
But at this point, I don't think Dad had invoked religion. He just said, I don't want my son to be exposed to these things.
Right. I was talking about his sort of how he framed his religion. Like the reason behind all of this is his religious beliefs. Right.
Yeah.
So,
but we started with the content and then religion gets added afterwards.
Exactly.
Yeah.
A few days later, district's director of elementary education responded to Dad's email. Okay. So this escalated very quickly. Meeting with the teacher, email to the school, district responds, Dad responds, and now we're up almost as high as assistant or full superintendent.
Right. Yeah. So if you're looking at like the org chart for this school, like teacher down here, principal, and then I think the director is probably in charge of all of elementary education in the district, then like above them is the superintendent.
Right.
I would imagine,
probably.
Or that's how most districts are. So like, this escalated to almost the top of the ladder.
Yep.
Very, very quickly.
Like within a few days.
Yeah.
Right. Like it's that quick.
Which to me suggests that like everyone knows how hot this issue could be.
Yeah. So we need to deal with it.
Right. Yeah.
So the director of elementary education took Dad's email and denied his request for an opt-out.
Oh, okay.
Yes. So not only did it escalate quickly, it really escalated.
I was going to say, we both elevated and escalated.
Yes, exactly. The response noted that, quote, parents have the right to opt out of required curriculum based on a sincerely held religious belief, unquote, but denied Alan's request on the grounds that his request was, quote, not tied to a sincerely held religious belief and is not specific as to what required curriculum is objectionable, unquote.
Right.
This is getting at the heart of the case. Okay.
Yeah.
You've got to tie your objection to a sincerely held religious belief, and you've got to specifically pinpoint what goes against that religious belief. Right.
Well, and that's an open question, is like, how specific are both of those criteria? Like, how specific do you have to be about the linkage between your sincerely held religious belief and the curriculum? And then how specific do you have to be in identifying particular curriculum?
Right. And that's one of those
yeah.
are two of the questions that Mahmoud didn't answer.
Right. Oh, and also like that question of like, does it have to be required curriculum? Like,
yeah.
Does Mahmoud only apply to that? Because that was a big thing in Mirabelli. The lower court said that, hey, like Mahmoud doesn't apply here because we're not talking about curriculum. The Supreme Court said, we don't think that's the right reading of Mahmoud.
Right. And so, this is where things start to get tricky, because, you've also got to look at the exact content of the communications that Dad sent, because if he didn't really invoke religion in those communications, then maybe it is fair for the school to say, you didn't give us the religious reasoning that Mahmoud seemed to require.
Right. Yeah. Because Mahmoud was based on the free exercise clause of the First Amendment. So like, it's not a free floating parental right. It's tied to religion.
But that's one of the things that, when the school says, your request isn't tied to a sincerely held religious belief, that's one of the things that I think came up. I've read so much about this, I can't remember if it was in the opinion or just in a response to the Mahmoud opinion. But like the question of what constitutes a sincerely held religious belief, is it enough for somebody to just say that's a sincerely held religious belief of mine? I don't have to justify it. As long as I just say it's sincerely held.
Right. And the linkage, right? Like it not only like, how do you question someone's sincerely held religious belief,
exactly.
but then also how do you question their interpretation of what contradicts their sincerely held religious belief?
Right.
And that's a really big question mark for me.
Yeah. Yeah.
Yeah.
I mean,
so many questions.
So many questions. So few answers.
Right.
So basically after that, just after the district denied his opt-out and said, you weren't specific enough with
and you didn't tie it to religion.
And you didn't tie it to religion. Alan responds that both he and JL were Christians who attend church on Sunday, and he reiterated his request that JL be removed from health class and from any DEI related curriculum.
Okay. So now the religion thing is
now
part of the picture.
Again, like some people might look at that and say, okay, just because you go to church, is that specific enough?
Right. What's the specific religious belief that you are alleging here?
Yeah. Right. Yeah. So after that, there was some back and forth between Alan, the director, the elementary school's principal, and it all culminated in Alan submitting a formal written opt-out letter to the principal a few days later. And keep in mind, everything that we've talked about so far is like all within a week, like 5 days.
Yeah.
And at the end of that 5 days, you've got this formal opt-out request sent from the father. And the letter requested that JL be exempted from, quote, lessons, events, school assemblies, or other instructional activities and programs which cover issues of sexual orientation, gender identity, pursuant to the U.S. Supreme Court's decision in Mahmoud versus Taylor.
Whoa. Okay. So like Dad knows about Mahmoud. Dad is invoking Mahmoud.
Yes, in his formal request.
Yeah.
Yeah.
And the request is now much more specific, right? Like it is issues, any material that is covering issues of sexual orientation or gender identity. So, we've kind of,
we're bouncing around
down a little bit.
Yeah.
Yeah. But it's definitely like
narrowing
for sure. Yeah.
Yeah. So a few days after that, Director of Elementary Education responded. In their reply, the school denied the request and asked for further clarification.
Okay.
Okay. The letter said that Allen's request was overly broad and required further clarification as it sought to opt out of broad topics.
Sure.
Okay.
And this is something like, yeah, because the question, like, if you're looking at this from the school's perspective, like, what does it mean for something to cover issues of sexual orientation or gender identity, right? Like, is it any time there's a man or woman in the story? Because that could be expression of gender identity, right?
Right.
Could it be any time?
It could apply to things that he actually has no problem with.
Right. Valentine's Day is the one that I always use as an example. Like, if you are trying to prohibit covering issues related to sexual orientation, that applies equally to heterosexual couples as it does to homosexual couples. So, like, Valentine's Day could fall under that. So, like, you know, Romeo and Juliet, classic example. So, like, yeah, I can see what the school is saying here. Like, right. Like, I know what that means to me. What does that mean to you, Alan?
Exactly.
Right.
And so,
so asking for clarification seems like a good call.
Yeah. And what it did was it invited Allen to resubmit his opt-out request with more information regarding a specific lesson, or to contact the school if he would like to review required curricular materials to better inform his request. And that's interesting.
That is right. Like, it's basically saying, like, hey, we don't have enough to go on here. Please help us. You know, assuming like best intentions from both the parent and from the school, right? Like, the school is saying, like, yeah, like, we hear you. Help us help you.
Yeah. Like, we don't know how far you want us to go with this opt-out request. So we need to better understand where your guidelines are.
Yeah. And that's one of the challenges of opt-out, especially the notice requirement. Because, like, requiring notice before instruction is provided to students in a lot of ways, like, depending on how vague you allow these opt-out requests to be, like, it's going to require districts to guess at what parents might find objectionable. And given the diversity of beliefs and values and views, like, how are schools going to be able to do that?
Yep. I wrote that in my notes here, that this is one of the big frustrating things for me about Mahmoud, is that what we're essentially saying is that schools have to anticipate what everyone could be offended by from a religious standpoint.
Right. Yeah. So, like, yeah, I totally understand the school's instinct to ask for clarification.
Totally. And by extension, that expectation on the school is like, okay, now we're expecting schools to be expert theologists as well. Right? Like, we have to know and anticipate what could be problematic for anybody's religious beliefs. And as we all know, just saying you're a Christian, or saying you're a Jew, or saying you're a Muslim, there is a very broad spectrum of beliefs
for sure
within religions. And so it's not a question of saying, well, as long as we can say this stuff violates the Christian faith and this stuff violates the Jewish faith, and just, you know, like, you can't do it. It's not going to work.
Right.
Anyway, so what did Alan do? Alan said, oh, that's great. I will come in. I'll review everything. I'll give you a very specific set of things and we'll move on. Right?
Yeah.
No, I don't think so. we did not get that.
Thanks
impression.
for listening, Ron. Your homework is to.
No, I think that response frustrated Alan.
Yeah.
Because, well,
he probably didn't feel like he was being listened to, or like he was getting the runaround, right? Like,
maybe. You know, like, again, like, there's so much of these cases,
right?
You know, whether it's, you know, Mahmoud, or this case, or the Kennedy versus Bremerton case, or where so much. You have so many questions about, like, what's motivating people.
Right.
We don't know.
Yeah.
Right.
I mean, bureaucracy can be frustrating for anyone.
You know, before Chris and I started recording this episode, we were talking about how frustrating bureaucracy can be. But anyway, yes, it can be frustrating. And we don't know exactly what about that response frustrated Alan.
Right.
But it was enough for him to go out and get a lawyer. And so
the lawyer up.
Yep. Here we go. So 5 days later, Alan's attorney gets involved and sends the school another letter saying that we expect that Alan will be notified and given an opportunity to opt JL out of any instruction or other required activities that normalize or promote LGBTQ identities or lifestyles, as well as the kindergarten DEI curriculum. So now
it's back.
We're back to, I guess Alan would say more specificity, and others would say now we're getting into the these very broad, undefined categories.
Right. And there is more specificity, right? Like activities that normalize or promote LGBTQ plus identities or lifestyles.
Yeah, that's the more specific part, but the bringing the
Yeah.
DEI curriculum back in is now a little bit more ambiguous.
What constitutes like normalizing or promoting, like that still feels squishy, right?
It does. But, given how this case goes, and everything we know up until now, just the idea or just the appearance would fall into the normalization category.
Right. Or at least that's probably Alan's perspective.
Right.
Yeah.
That's what I mean. Okay. So, as fast as everything moves at this point, unlike this show, this is where things hopefully will start to speed things up. But in the case, this is where things start to slow down.
Right.
All right. So the next thing that happens is 2 weeks later, Alan receives a letter from the Lexington Public Schools legal counsel. As soon as you bring your lawyer in, then everybody brings their lawyers, and it's just a fun lawyer party.
Yeah, it's a lawyer arms race.
Yes. And the district's response, obviously from legal at this point, was to again deny the request, calling it overly broad. It again invited Alan to review the kindergarten curriculum and classroom books with school leaders in order to narrow his opt-out request to specific materials. So that gives me the impression that when he was offered that the first time, he did not take advantage of that.
Take him up on it. Yeah.
So while all these letters and emails are flying back and forth between Alan and the school district, JL was in kindergarten, doing what kindergartners do, hopefully learning. Well,
hopefully.
Yeah. Perhaps unsurprisingly, Dad objected to some of what he was actually learning. And during this time, Dad alleged that JL had been read 2 books. One of them, Families, 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 and the other one was All Are Welcome, which he felt directly violated his opt-out requests.
Okay.
But he only found out about those books after the fact. He did not go in. Clearly, we know at this point, he did not go in to find out that those books were going to be read.
Right. And the school didn't notify him.
And the school did not notify him that those books were going to be read. They merely said, you want to find out what we're doing? Come on in.
Right.
Okay. And again, that goes back to my concern before about asking schools to anticipate what everybody is going to be offended by. Like maybe that was the school's way of saying, we can't do that, but here we will give you everything and you can tell us.
Right. It needs to be an equal responsibility at the very least, right? Like both parties need to have some responsibility. Right.
So those 2 books, Families, Families, Families shows anthropomorphized animals in various family arrangements, including families with 2 dads and 2 moms. And the book All Are Welcome shows pretty much what the title says, different kinds of people who are welcome, including an image of 2 women, both holding a young girl's hands, with one of the women being depicted as pregnant. The assumption being here is that it's a same-sex couple.
Okay.
It's an assumption. It's not, sort of explicitly promoting this. It's just like, hey, here's this family.
Right.
Okay. In addition to those 2 books, Alan's going to go on to ultimately object to 8 other books.
Okay. So he does review the curriculum at some point.
At some point he does. I don't know if those books were in the classroom library or the school library or what, but he objects to 8 other books. Some of those books were identified in the Mahmoud case, like Prince and Knight, but there's a number of other books. In addition to those books, Alan also objected to various lessons teaching themes related to diversity, equity, and inclusion.
Mm-hmm.
Again, okay?
Okay.
So we've got this opt-out request and the back and forth with the district. We've got the objections. And then what happens?
Well, you'll never guess. But about a month later, Alan filed a lawsuit.
Oh, hey.
Yeah. And as part of that lawsuit, a couple weeks later, he moved for a preliminary injunction. And that's the court decision that we're talking about today, is the court deciding on that preliminary injunction. So the case is still ongoing. This is not done by any stretch.
Right. The preliminary injunction is just when somebody asks a court to pause the thing that could be causing the problem. In this case, it's being denied the opt-out. So
exactly.
He's asking the court to say, stop the school from stopping my opt-out. There's all this lawyer double negative
double
stuff,
negatives. Yeah.
right. But like, it's basically saying, let me have the opt-out while this plays out in court.
Yeah. Press pause on the stop button.
Oh my gosh. Okay.
Right. So he wants the court to force the school to honor his opt-out request.
Okay.
While the case is ongoing.
Okay.
And one of the most important elements for whether or not to award a preliminary injunction is whether or not the plaintiff has a likelihood of success on the merits. So with that in mind, important to note at this stage that we have not done discovery. So like, we're basically kind of going on what is contained in the complaint, or what basically this is Alan's version of events, or what he says happened. There are some like sworn statements and exchanging of documents and things like that at this stage, but like, we don't have a full picture of what actually happened. So things might be different once the facts are fully developed here, but the court at this point can rely on Alan's version in deciding whether or not to grant the motion.
Okay.
So let's get to the merits of Alan's claim. His argument is that, applying Mahmoud, which he's already mentioned in his letters, the school violated his free exercise rights by not honoring his notice and opt-out request. Obviously, the school disagrees.
Okay.
So this entire case hinges on how the court understands and applies Mahmoud.
Right.
And interestingly, the court starts by saying like, hey, the facts here are very much similar to the facts in Mahmoud. We've got pretty much the same facts. You've got books that a parent objects to on religious grounds based on LGBTQ plus identities. So these are very factually similar.
But are they?
But are they? Good question. Let's put a pin in that.
Okay.
So the court summarizes the holding of Mahmoud as saying that, quote, governmental action that substantially interferes with the religious development of a child presumptively constitutes a burden on the parent's free exercise rights. And you can only justify that burden if you satisfy strict scrutiny, meaning that the curriculum is necessary to achieve some really important governmental interest. So everything comes down to that phrase, substantial burden. In Mahmoud, when we talked about Mahmoud, I talked about like my reading of the case as requiring kind of like a content plus context standard for what makes something a substantial burden. So it's not just what the book says, it's also how the school
Is teaching it.
is teaching it, or like, how they, like what they say about the book.
And they had, and Mahmoud had like all these curricular support documents for teachers, and they had training, and they had, here's how you respond to parents when they ask questions. And like, there was
and they also adopted the curriculum because they didn't feel like they had sufficient representation of these different identities.
Right.
And I think somewhere there was something that said like, we did it in order to disrupt kind of heteronormative ways of, or, cisnormativity.
Yeah.
And so like you ask that question, like, is this really similar to Mahmoud? And that's where I think things are so different, because Mahmoud was all about that context of how these books were presented.
Yeah. In the argument, they spent most of their time, well, maybe not most, but they spent a significant amount of time talking about...
There's also some literary criticism and analysis.
Yeah, the book club.
Yeah. The book report.
Yeah. But like they spent a decent amount of time talking about the district's intentions behind the curriculum and how they implemented the curriculum and all of that stuff. And that's not in this case, is it?
Not so far. Yeah, there's no factual record about any of that. So yeah, we've got the content, but maybe the context is missing.
Okay.
And so, the court shares that reading of Mahmoud. It says that, Mahmoud is a very fact-intensive inquiry that looks on lots of different things or looks at lots of different things. It looks at the specific religious beliefs and practices asserted. So like how specific are you about your religious beliefs and how they interact with the curriculum? The age and maturity of the child. So like the younger the child, the more impressionable they might be. And importantly, the context, including whether the material is presented in a neutral manner or in a way that is, quote, hostile to religious viewpoints and designed to impose upon students a pressure to conform. Right. So like that's the content plus context.
Exactly.
And so, you know, that's how I read it. But then when we get to the application, this is where me and the court tend to diverge a little bit.
Yeah.
Because if we haven't said it already, the court is going to find for the parent. And so for the court, this is a straightforward application of Mahmoud. It is a 1-for-1. The court even says, look, Dad is objecting to Prince and Knight. And that was one of the books the Supreme Court said violated parental rights in Mahmoud. So because it did it there, so too here. And, you know, it goes through all the other books and says that, you know, all of them teach about, teach that any arrangement of people of whatever sex can be a family so long as they love each other. You know, that's kind of the message of all of these books. And so the court basically says, like, you know, that's just like what Prince and Knight did. So therefore, those two burden the family's religious rights. So yeah, no reference at all to the context.
Right.
Of how these books are being presented.
Right.
So I think like that misses the mark on Mahmoud pretty significantly.
Right. And also at the same time, no reference to addressing the ambiguity that was raised in Mahmoud with respect to the notification and how we define, you know, substantial religious burden or whatever the language was. And, you know, look, maybe that's going to come up as this case plays out, because again, this is just the preliminary injunction.
Right.
But I hope it does one way or the other
so too.
Because, you know, the stuff that we were left with ambiguity wise from Mahmoud, at least at the preliminary injunction stage in this case, we didn't get answered.
Right. And this opinion does not touch the procedural questions, and it doesn't touch the question of like line drawing about like how specific you have to be and all of that. It's like none of that is touched.
It's more about like, does this guy have a case?
Well,
I mean, it's not, I'm overgeneralizing, but it's like, that's what they're kind of asking at this stage.
Right. And I wish the court had addressed those kind of procedural things, because like, is it enough for the school to say like, hey, come on in and look at the curriculum and then tell us what you don't want?
Right.
Like, is that enough to meet your obligations under Mahmoud when someone raises a concern? Like, I think that's a really necessary question that needs to get answered, right?
Well, I mean, but that's what our schools need to know, right?
Exactly.
Those are the questions they need to have some guidance on.
Right. Right. Yeah. Because right now there's so much ambiguity in all of this.
Yeah.
And so many open questions, as we've alluded to.
Right.
One interesting thing that the court does acknowledge, though, and this goes to something, Jamie, you said earlier, is that there might be a distinction between books that seem to take a position on sexuality and gender versus ones that just happen to depict gay or lesbian couples.
Oh, okay, good. Okay.
But in a footnote, the court said, there might be a distinction, but we're not going to deal with that right now. So that's for another day.
Of course.
Which is such a dodge, I guess. Like,
yeah, well, they've been doing a lot of that. They've been sea changing a lot, and they've also been dodging a lot, these courts.
And that dodges that question of line drawing of like, you know, where is the line here for like what actually interferes with your religious beliefs.
And listen, it's those lines that matter. And we know from history how important those lines are, especially when it comes to religion kinds of cases, right? Like look at it's exposure versus coercion, right? And that understanding of that line has been central to so many cases. And so dodging that question is, to me, it's dodging the hard work that is needed.
Right.
in these
And I think that
situations.
this entire opinion dodges a lot of hard work because it basically just says like, oh, well, Mahmoud was about the same books. So therefore the outcome is the same.
Yeah,
And I don't think that's
feels that feels like what's the,
right. Yeah.
like
A cop out.
a cop out, but almost childish isn't the right word. It's just like
Simplistic.
it's simplistic. It's not. It doesn't deal with anything.
Right. Yeah. Not like us.
Yeah.
Yeah. So, the court ultimately finds that there is a substantial burden here on the parents' religious liberties. So that means we have to apply strict scrutiny. We've talked about strict scrutiny before, but basically it's a means end test. Like,
Yeah.
are you trying to accomplish something that is really, really important?
Right.
And is the way you're doing it something that like is a tight fit between what you're trying to accomplish and how you're going about it?
Mm-hmm.
And here, like the court spends zero time on whether or not this satisfies strict scrutiny. It basically just says like, well, schools do have a substantial interest, like they said in Mahmoud, in basically having a sound educational environment, but denying the opt-out here doesn't really implicate that interest. So there's not a narrow tailoring. So burden on religious, this is a substantial burden, doesn't pass strict scrutiny, therefore dad wins. So that's everything the court wrote in its opinion. So missing from all of that, as we just alluded to, is any help on like the procedural questions and the line drawing questions. But here's a really interesting wrinkle. The court issued an injunction basically saying to the school that they needed to make reasonable efforts to ensure that JL was not exposed to the specific books that were mentioned. The injunction also required the school to provide copies of all other LGBTQ plus materials that JL might be exposed to dad so that he could identify materials that he thought violated his religious beliefs. And it sounds like Alan did that. So the school provided the stuff. Alan looked at it because we ended up back in court. Really? This is a really interesting wrinkle. So dad identified some more books that he thought violated his religious beliefs. And the school objected to 2 of them.
Oh, really?
Yeah. So the 2 books that the school said, no, those don't fall within your injunction were Pink is for Boys and Except When They Don't. Now, both of those books complicate gender stereotypes for kids, right? So like Pink is for Boys, it's just a bunch of different colors that can be for everyone. And the last page of that book, we have it at home, is like every color is for everyone. Boys and girls. And then Except When They Don't is all about stereotypes and people and children like subverting stereotypes about what's appropriate for boys to play with, what's appropriate for girls to play with.
Okay.
And the school argued that those books don't burden dad's religion because dad said that things that promote LGBTQ plus identities burdens his religion, but those books only relate to gender stereotypes, not gender identity or other LGBTQ plus characteristics.
Oh.
So there's a distinction here between gender identity and gender stereotypes. And guess what? The court agreed.
Oh, interesting. Okay.
I know. That's a really interesting wrinkle. So the court said that dad's stated religious beliefs were all about gender identity and sexual orientation, not gender stereotypes. So no right to opt out from those 2 books.
Okay.
Which, like talk about line drawing.
Yeah.
Now we're drawing a line between gender stereotypes and gender identity, which is a tough line to draw, I think.
Yeah.
But, that's where we are now. Litigation is still going on. There's a number of motions, including a motion to dismiss from the school. So we'll see what happens. But as things stand now, the preliminary injunction is in effect, and Alan has the right to opt JL out of most of the challenged LGBTQ plus inclusive books.
And listen, it's entirely possible that this case could go on for another year, 2 years,
right?
Who knows?
And end up in the Supreme Court.
And could end up in the Supreme Court. And throughout that time, the school is essentially responsible for providing Alan with every time this kid goes into the next grade, like, okay, now the first grade curriculum, now the second grade curriculum, we have to identify every book that has, an LGBTQ couple or a this or that. We've got to push that out to Alan.
Yeah, it's a pretty significant burden on the school, right?
Yeah, it is. Now, I don't know if I was the school, or the district, I would consider Like, you know what? I mean, what do we need to do? Should we, if we're pushing this out to this guy, do we put it on, on our website and just make it available to everybody so that we don't have to go through this individually?
That is a massive question that schools are dealing with. And every school, I think, since COVID especially, has taken steps to be more transparent, because I think COVID, it identified the start of kind of like the new parental rights movement that we've seen, where parents are objecting to curriculum. Like, schools have to be more transparent about what is taught and how it's taught. The question is like, how far does that go, and how proactive do they have to be? What do they have to make available? Like, when do they have to guess what's going to violate someone's sincerely held religious beliefs? All of that.
Yeah. Well, I mean, I really hope that we can actually drill into some of this ambiguity over the next little while. Again, like we said, there's probably a lot of other cases that are percolating or about to percolate. Right.
It's one of my favorite legal terms, percolating.
Yeah. Yeah. Well, I'm a big coffee fan, so I use it too. But I mean, this is, we're in new territory here with this, and what this is going to mean for schools, because, the other thing we didn't really talk about today is like, okay, this kid's being like, how much material does this apply to? And, we know, especially in kindergarten, in these early grades, like, there's potential carryover. It's not like we only do these kinds of lessons between 8:30 and 9:30 in the morning. Like, there's a lot more, the lines between lessons and how the day is structured in those earlier grades. It's a lot more nebulous. And what we didn't really touch on is like, okay, when the opt-out is granted, what then?
What does that look like?
What does that look like, both in terms of making sure that the child isn't exposed to that material and supervised wherever they go? Do they have a place to go? Do they have somebody to supervise them there? And what are they going to do when they're there?
Right. Do they get an alternate assignment? Do they get an alternate reading? Like,
Right. Or is a school just going to turn around because it's, such an extra burden on them or whatever, and just say, hey, you get an extra recess? Like, who knows how that stuff is going to play out?
Or does the school take these books out because they just don't want to deal with the whole issue?
Right. And and we've talked about that before, is the potential watering down of the curriculum.
Right.
Because, and listen, some people will say that's not watering it down. That's taking unnecessary stuff out of the curriculum. I get that there are multiple sides and multiple viewpoints to this, but the point we're trying to make here is that there are some really real implications for schools here, and we don't have the answers we need yet.
Yep. But hopefully we're starting to paint a more clear picture.
Yeah. Did we?
We're working on it.
I think we did.
It's
or at
percolating.
Least we gave you lots of good stuff to think about.
Yeah.
Yeah.
Exactly.
Right.
It's almost like we're professors.
We're not going to answer your questions. We're just going to give you more.
Let me answer your question with a question.
With a question. How do you handle this? How do you think you should handle that?
It's very Socratic. Yeah.
Oh boy, folks. All right. What's your homework? What do you think your homework should be?
What do you think your homework should be? You could probably answer this if you listen to the show enough. Your homework is to go to chalkandgavel.com, check out our website, check out all the cool merch there, find us on social media at Chalk and Gavel, like, rate, review, subscribe, all of that fun stuff. It's a huge help for us in the algorithms to get that kind of interaction. So we would love to hear from you, and stay tuned as we try to answer these questions with more questions.
It's also very important that we mention this. This is some new information here, but Chalk and Gavel is supported by the generosity of the Martha McCarthy Education Law and Policy Institute at Indiana University.
That's right.
At their School of Education. All right.
We've hit it big time.
We have hit it big time. They are wonderful supporters of the show, and we want to express our appreciation to the wonderful folks there at the Martha McCarthy Education Law and Policy Institute at Indiana University. They've got great resources for educators, for school leaders, for attorneys, for policymakers, professors. They've got an annual conference that they do in June, and we thank them very much for their support.
Yeah, they're doing fantastic things, and we love that they see the value in what we're doing, and all the collaborations we can do with them.
That's right.
All the better.
That's right. All right. Well, that does it for us on the show, and we hope that you have a wonderful couple of weeks as you digest this episode and eagerly anticipate the next one. And we will see you then. Have a good one, everybody.